A very good afternoon, everyone present here. I, Huma Khan, Assistant Professor of Law, on behalf of Faculty of Law, warmly welcomes you all at this virtual platform in the second module of Faculty Development Program on Integration of Intellectual Property Rights, Principles into Teaching, Research, and Professional Activities. For today's session, our topic is Ethical and Legal Dilemmas, Intellectual Property in Academic Research. On this topic, we have with us to discuss Dr. Gulafroz Jan ma'am with us. Dr. Gulafroz Jan has been working as a senior assistant professor in Department of Law, Central University of Kashmir since 2012. She has also completed her bachelor's, master, and PhD from the same university. Her area of specialization is intellectual property laws and has done her research on the topic emerging dimensions of trademarks laws. She has one book, a number of research articles to her credit in the field of research. She has guided almost 30 scholars in their master's dissertation, is also recognized research guide for PhD scholars. Apart from her academic contributions, she is also actively participates in administrative work of the university and holding various posts in the university in her capacity. She is having national and international publication in various reputed journals. She has presented approximately 20 research papers at national international seminars, conferences in India. Recently, she has completed a major research project titled Domestic Violence in Kashmir Legal Framework for Enforcing Women's Rights, which was financed by National Commission of Women, New Delhi. She has been resource person in number of conferences and workshops and delivered lectures on emerging dimensions of IPR and issues relating to women. So now, without wasting much time, I would like to invite the ma'am for today's session. Ma'am, now the house is open for you.
Uh, Thank you so much, Dr. Huma. At the very onset, thank the organizers who have invited me for this talk. The way you gave my introduction, I'm not worth it, but I'm trying to come up to the expectations which your university is having from me. Try my best to discuss the ethical and legal dimensions in the intellectual property. Can I share? Is my screen visible to you, please? The slides.
Yes, ma'am.
Okay. Okay. So, taking up the ethical and legal dilemmas in intellectual property in academic research is one of the areas which is, a new dimensions. Like these ethical issues are there, and we have to understand the complexity of these ethical issues, and at the same time, there is also a need to protect the intellectual property right. And since intellectual property right is something which is monoplastic in nature, and it envisages that the person who is having those rights will be having exclusive rights over those things, but at the same time there are certain things which a person has to take care. So these issues arise especially in certain domains of intellectual property which are touching the ethics also. So we have to make a balance between the ethics and innovations. So today's lecture will be totally understanding the complex interplay between law, ethics, and innovation. So, if we first of all see what intellectual property law relates to, or what intellectual property is, these are basically the legal protections which are granted to creators for their inventions, which are whether literary or they are artistic work, or they are symbols, names, or images which are used in commerce. The intellectual property right basically exists at the intersection of ethics and law. It seeks to balance the protection of creators' right with the broader public interest. This balance is very crucial, dear faculty. I hope the audience is all the faculty members. I thank and welcome them all at the very outset before I will further proceed. Understanding this, the IPR is basically the balance is to be maintained, and it's very crucial as intellectual property involves not only the economic right of the individuals or corporations but also the moral questions about creativity, ownership, access to knowledge, and innovation. Of course, there are a lot of ethical and legal dimensions which are basically related to those IPRs. IPR law provide a legal protection for creations of the mind, such as inventions, literary work, and different types of IPRs are recognized for example, copyrights, trademark, trade secrets, and designs. The primary purpose of all these intellectual property laws are, you know, to incentivize innovation and creativity by granting creators exclusive right over the use of their creations for a limited period. These rights allow creators to control the use, distribution, and financial benefits of their work. Having said that, the ethical dimensions or the ethical dilemmas, which are very common in relation to, I'll be trying to touch only two types of IPRs, whereby we can discuss at a stretch these ethical and legal dimensions. The first one will be the Copyright Act, and the second one will be the the Patent Act. Now, the dilemmas are basically in relation to some areas. These ethical and legal dilemmas surrounding intellectual property in academic research are no doubt very complex, and they involve not only the person who is the author, not only the person who is the innovator. It all includes all the stakeholders, including researchers, universities, funding agencies, and of course the society at large. Some of the main ethical dimensions or some of the main ethical concerns or in these two, especially in the copyright and and the patent, are authorship and ownership conflicts, number one, which we'll be discussing, open access and proprietary rights. Third, we'll be discussing plagiarism and attribution. Fourth, I'll be highlighting on AI and IPR. Fifth, digital piracy. Sixth, patent and stem cell research. And then pharmaceutical patents and access to medicines. Now, if we look to the first one, authorship and ownership conflicts. The basic ethical issue in this authorship and ownership is who is getting the credit for the research, because there is always a power dynamics between senior and junior researchers. There is always a power dynamics between the industry and the researcher. And if we look to these authorship and ownership conflicts, we can broadly categorize them. And there are authorship and ownership conflicts in intellectual property within academic research are basically the common issues that arise due to collaborative nature of the research and the overlapping interest of the various stakeholders such as researchers, university, and funding bodies. These conflicts often pertain to who deserves the credit of the research contribution and who has the right to own the benefit from this intellectual property resulting from that research. The authorship, if we talk about authorship and the person who is the author of the research, he's always having his side of the coin. He wants to always have his side of the coin. So authorship dispute arise when there are disagreements over who should be credited in intellectual property. Authorship in academic publications reflects both contribution and responsibility. And of course, disputes can occur over the several issues. For example, there is always an undue credit. Individuals who have made minor or no contributions may ask sometimes to be a part of this authorship. They want to be a part of this authorship. As happens in research, that if you take a help from some person, or for that matter, I'm sorry to say, if you are having some of the persons with whose affiliation you want to publish a research paper, even if there is no credit of that person in your research, he also wants that authorship right. So the individuals who have made minor or no contributions may be included as authors due to power dynamics. Okay, so these are like your, sorry to say, your supervisors, or even if supervisors are there, they are having their equal role. But at the same time, the people who want, with whom you want your journal, you want your paper to be published in a journal, or who have done some minor help to you, and they will be rendering that technical help only on the premise that you will want them to be they want you to make them authors. And then sometimes it is due to power dynamics, sometimes it is due to political pressure. This is known as honorary or gift authorship. This is one of the considerations in authorship considerations, ethical considerations. Then omission of contributors. Sometimes contributors might not be credited for their, sometimes it happens that you might not give due credit to some contributors. Again, this is again a very, very important point. And then discrepancies in collaborate contribution. Researchers may agree on the level of contribution required for authorship, but there may be conflicts between junior and senior teachers regarding who should be the first in the list of being the author. And then how law is taking care of all this law and institutional aspects. If we see, many universities and journals have specific guidelines for determining this authorship, often based on international standards such as guidelines set by the International Committee of Medical Journal Editors. So they're having their own guidelines, and that contribution you have to also show what type of contribution which type of author has done. And then in case of academic publications, authors hold copyright unless they transfer it to journal or to the other entity. So author is having an copyright of a thing unless it is transferred to some publishing authority or it is transferred to some journal. And disputes may arise over who is legally recognized as an author in situations where the work of ownership impacts subsequent users. Then ownership conflict. This was in terms of like authorship, and then in terms of being an ownership of an innovation or being having an ownership over a copyrighted material. Ownership conflicts focus on who has the legal right to control, use, and benefit from IP generated by academic research. These disputes often arise due to involvement of multiple parties and varying expectations regarding the commercialization of the research. And then, if you see the key areas of conflict in this ownership are university versus researcher ownership. It happens with all the researchers. So, if you are researchers in some field, you will also face those difficulties. Many universities claim ownership of IP created by faculty and students under their employment or enrollment, especially if the research was conducted using university resources. This is again very important. This is often codified, in the employment contracts or the university policies. But the researchers, on the other hand, feel that their intellectual contribution entitle them to ownership on a significant share of profits. And then collaborative research is again another field where ownership conflicts do occur. So when multiple institutions or research collaborate, conflicts may arise as to how IP rights should be shared. Disputes occur often on the division of ownership between the parties, especially in international collaborations where IP laws differ by jurisdiction. So interdisciplinary research also raises challenges as how different fields might have contrasting norms regarding the intellectual property ownership. Even funding also determines that who will be having ownership. So if there is a research agency which is funding you and that research agency is a government agency, then definitely it will amount to like many, the government may impose certain conditions on the ownership of your ownership or sharing of intellectual property with some other person. Some may require that IP resulting from the funded research be shared with the public, and some may say that no, it is funded by the government, and sorry, it is funded by some agency, and the research shall be open to only that agency. So conflicts occur when researchers or universities wish to patent or commercialize findings, but the funding agency mandates open access or sharing of the results. Now, what are the legal implications in these ownership and authorship problems? So, as I said, disputes often arise over patent rights when multiple research contributors are there to a discovery or innovation. Legal ownership of patent generally, as per law, rests in the employer unless otherwise agreed upon. This is very important to understand. So if an employer is funding you, and if an employer is giving you providing you research and development, if employer is providing you money, if employer is providing you incubation center, if employer is providing you all the facilities of doing the research, then the ownership rights of the patent will definitely rely or will be entitled to the employer unless otherwise agreed upon by determining inventorship as may be contentious. If the invention is commercialized, conflicts can arise over how revenue from licensing and product sales is distributed between the university, individual research, and of course there needs to be a mechanism whereby profit sharing is very important to understand. Like if any funding agency has giving you funds for doing, but at the same time, you as a researcher shall also be having some rights in your research, and to what extent you are able to give your rights to the funding agencies, and to what extent you are able to get money out of the relinquishment of rights towards that funding agency. In copyright, ownership of research publications can also lead to conflict, especially when the researcher leaves the institution. So these are the legal implications. For example, if I am working in Central University of Kashmir, I am having all my publications, which will be actually in the credit of the university. When, for example, there will be an IRF ranking or NAC ranking, my contributions will be counted in the university. But tomorrow, if I leave that research institute, if I leave that, I will, what will happen to, definitely I will claim my rights to be with me. And especially a researcher, when a researcher leaves the institution the research was conducted, will lose that right. Okay, so question of copyright transfer from researcher to journal can complicate. So for example, if a person is doing a PhD in a particular institution, the institution may take his copyright for 10 years or 20 years, and then tell him that you cannot publish unless you get a permission from the university. So this is how the things are to be managed. Then the second area on which there are ethical issues arising is open access and proprietary rights. We understand that whether for example, if you are writing a paper, you want that this paper should be accessed at the one end. The debate between open access and property rights in academic research is very crucial, and it revolves around the ethical questions regarding how knowledge should be shared, who has an access to it, and how is it is controlled. This tension arises particularly when the research, often public funded research, results in valuable intellectual property or commercially viable products. Now, if we look to the access to knowledge, the first question which arises, which is basically an ethical dimension in open access and proprietary rights. We say open access promotes idea that research, particularly public funded research, should be freely available to all. It All the people throughout shall have access to the knowledge or access to the research material, which is available on the internet, or it should be freely available to all without any cost. This allows for the dissemination of knowledge without financial or legal barriers. It fosters global collaboration and innovation. But at the same time, a person who is having copyright under the intellectual property rights, that he claims proprietary rights and involves restricting access to research fundings through, he also generates paywalls and then patents and exclusive rights, and often justify the need to recoup the investment costs or protect innovation. So the ethical issue in these things, when we talk about open access and proprietary right, is restriction of access to research, especially life-saving or socially beneficial discoveries, can be seen as ethically problematic. So if we restrict the life-saving research, it is not ethically good. So what I mean to say is that the life-saving research and socially beneficial discoveries shall be open to the public, because it raises questions of fairness and social justice. As those who cannot afford expensive journals or subscriptions, or they cannot afford patented technologies, are excluded from benefiting from this option. So, no doubt, proprietary rights are to be taken care, proprietary rights are to be respected, but at the same time, what is in the public domain must be, what is in the public, for the public benefit, it must be open in the public domain. Then, in relation to these open access and proprietary rights, one more dimension is innovation and incentives. There are open access. If we see, critics argue that without proprietary rights, researchers and companies may lack the financial incentives to invest in costly research and development. Patents and other forms of IP protection provide a period of exclusive control that can recoup investment. But when we talk about proprietary rights, strong IP protection encourages innovation. So when you are throwing open the researchers, people are losing their, these proprietary interests in that. And then open access things, they are having lack of financial incentives, definitely. But when these rights are to be, for example, given, proprietary rights are recognized in the form of copyright, it encourages innovation by rewarding researchers and companies with exclusive control over those discoveries. However, it can also stifle innovations if excessive restrictions prevent others from building on those existing research. Now, the ethical issue is how to strike a balance between incentivizing innovation and ensuring that new discoveries are also accessible and can be further developed by others. So, excessive IP protection can lead to patent thickets that hinder progress, while open access may fail to offer sufficient rewards for innovators. So we have to strike a balance. So ethics demands that we cannot incentivize our innovations. We cannot have abuse of monopoly at one end. But at the same time, you have to throw open the research which is beneficial to the public. And then, in case of ethical dilemmas in health and medicine, again, the life saving drugs. In medical field, open access to research can be for life saving drugs, especially when it comes to new treatments, vaccines, or drug discoveries. Open access allows the rapid dissemination of crucial knowledge, but at the same time, the proprietary rights, the monopolistic rights under these patents, patented drug treatment or medical devices is common practice, allowing companies to maintain their exclusive right and charge higher prices and recover the costs of research and development. However, this can limit the access to life-saving treatment. So how these issues are to be resolved? There is a fundamental tension, of course, between the need to reward pharmaceutical agencies and medical innovations through patents and moral imperatives to provide affordable life-saving treatments. So high drug prices due to patent protections can create ethical dilemmas in access to the healthcare. So we have to make a balance between providing life-saving drugs to the people at the affordable prices, and of course maintaining the proprietary rights of the individuals who have worked on those drugs. Now, the third important point is plagiarism and attribution. Now, again, a very important and a point of concern, which concerns all of us as researchers. So, ethical dilemma is what constitutes plagiarism in research and how to prevent it. Now, if we see plagiarism in academia, what does it mean? If we look to the section 54, or sorry, section 52 of the Copyright Act, it talks about the doctrine of fair use. Like, for example, if you are using the things, if you are using the copyrighted material for the purposes of your research, for the purposes of your class lecture, for the purposes of your, other reasonable work, which is related to your academia, then you can use it. But at the same time, what are the limits of using that work? So using someone work without proper attribution. So even if in case you might also be knowing, all of you as researchers, am I audible? Hello? Hello?
Yes, ma'am, you are audible. Please
Please
continue.
confirm, because this is a one-sided affair and you never know whether people are listening to
Um,
you or. Thank you.
yes, yes,
Please,
ma'am, you are completely audible.
please tell me if my voice is not, audible there, please. So I was talking about
Okay, ma'am.
plagiarism. So the thing is that when you are using someone's work, you have to give attribution to it. Definitely, you need to recognize the person from whom you have taken. So using someone's work will, it will lead you to trouble if you are not properly attributing it. And the types of plagiarism or the forms of plagiarism can be like, it's a copying verbatim, which we don't do usually, but reusing one's previous work, combining information from various sources, and incorrect citation or oversight. Now, the academic integrity, demands plagiarism basically erodes the trust of and fairness. It undermines the academic credibility. We have to see, the originality and creativity. And consequences for the students are that they'll if for example, god forbid, in your academic research, for example in your phd or in your projects, or if it is seen that your work is plagiarized, definitely you will fail in the grades, you will be subject to suspension, you will be subject to expulsion, and your image will be tarnished, your academic records will not get fine. And the legal implications of it are, while plagiarism is primarily an ethical issue, so you have to be very cautious while using somebody's work. It can also intersect with copyright law when the plagiarized work is protected under copyright. In such cases, plagiarism may lead to copyright infringement claims, resulting in the legal actions and financial penalties. So if we see, we're having a number of cases in India, starting from Arjian and Deluxe Films. It established that mere similarity does not constitute copyright infringement unless substantial parts are copied. The similar way, like in Bright Tune Music versus Harrison's Music, found that George Harrison guilty of subconscious plagiarism. Now, emphasizing the importance of originality. Even if it is subconscious plagiarism, you have to be very cautious about it. Plagiarism, we at the institutional level, we are having some tools to detect this plagiarism. We're having Turnitin, we are having Grammarly. Now, if you know, the latest version of the Turnitin also recognizes the plagiarism in AI. So it is not only plagiarism of the, whether the matter is produced by, AI or not. This is again very important. So Turnitin and Grammarly, and then importance of understanding. We need to understand that, it's very important to understand the academic integrity, and we have the universities are having their clear policies on the and on plagiarism, and of course the consequences of plagiarism. Some of the universities allow 10%, some of the universities allow 20% similarities. This all upon the universities. And then again, a very important aspect is data sharing and privacy. So we have to have a balance between the need of open data in research and participants' private rights, which I was discussing right now. And the fourth point is digital privacy. Sorry, digital piracy. Now, what is this digital piracy? Digital piracy is basically unauthorized online distribution of copyrighted material. You might have seen that. This is a new threat which refers to unauthorized use, reproduction, or distribution of digital content, such as music, movies, software, and books, usually facilitated through the internet. It involves complex ethical and legal issues, and it pits intellectual property rights into the financial losses and creators against excess freedom and public benefit arguments. The ethical issues in digital piracy are violation of intellectual property rights, impact on artists and creators. We understand that. Corporate greed and overpricing are there. The issues in the digital piracy, if we'll take up these issues, these are copyright infringement. Definitely, when there is piracy, the use of music or use of the content by some other person digitally, it definitely will, infringe the copyright of some person who is there, and it results in the loss of revenue to the person who is holding that copyright. And there are internet piracy laws which are there to help, but of course this digital piracy is one of the biggest problems at this time. There are important cases whereby super cassettes industries and MySpace, you might all be knowing that, and they were liable for hosting the infringing content on the website. In Capital Records, Nick versus Reedy Jean ruled that digital files cannot be resold under the first sale doctrine, even. So, doctrine of originality needs to be protected. And then again, a very important, point in this plagiarism or in this fair use comes the parody. Now, what is this parody? Parody is the use of the someone's copyrighted material for the purpose of comedy, for the purposes of criticism. The question arises whether that use of parody is violating the copyright of somebody. So we see that limited use of copyrighted material without permission for the purposes of criticism, comment, news reporting, teaching, or research is not what you can say infringement of the copyright. So in Academy General Education Manipal versus Malini Malia, the use by the educational use of copyrighted material by the for the educational purposes was not regarded as the infringement or the violation of copyright. In the similar case, Campbell versus Akuf Ross Music in 1994 recognized parody as a fair use. So it's very important to understand this parody can be taken as a fair use. So even if it is commercial in nature, but the only thing is that you have to justify that it is parody. And then one of the biggest ethical dilemmas, which is now in vogue, is relating to AI, use of AI in copyright and patent. The biggest ethical dilemma in use of AI and copyright is that can AI generate its own intellectual property? Okay. And should AI have access to copyright materials for training? Current laws are very silent about it. There is nothing in the current laws, whether it is trademark law or whether it is patent law, which is directly talking about the ownership and authorship of the work in AI. Now, if we look what artificial intelligence this time is, we understand that artificial intelligence system is growing at an exceptional rate in today's progressive tech-savvy world. With more sophisticated form of software being incorporated to them, AI enables systems to transcend from performing simple calculations to productivity, producing poetry, artwork, and more complex creative work. And it's here where the problem arises. This raises a question of whether or not such work can be afforded any special status under the intellectual property laws, like any other form of work produced by an identifiable human resource. Now, so the pertinent question or the pertinent problem which is concerning intellectual property rights is that AI challenges not only the traditional notions of the concept such as patents and copyright, but it also leads to emergence of questions related to the regulation of such creations. Though the intersection of AI and copyright is not new, we understand that. And it has been going on from many years. Even earlier, there was no dispute pertaining to the fact, but who will have the copyright over the work because the program or the machine just worked as a tool in the same way our pen and paper used to. But with the advancement in AI, if you see nowadays, work is being created by AI. We take the help of ChatGPT and AI for creating our works. So with the advancement in AI, when there are, when we are creating machines with human intelligence, which is capable of creating original work on its own, and the question is, who will have the copyright of that act, of that writing? That's being raised as to whether the copyright will go to the programmer, the person who made this AI, or the AI machine itself. So machine learning is something which falls within the ambit of AI and in which the data is being fed and machine or program and it's controlled by the human. Now, who has the authorship rights in case of AI creative works? So all over the past decade has produced, like we have seen, if we look to the the works which has been created by AI. We see the policeman's beard is half constructed by an actor, an AI designed to generate prose and poetry. This is an AI work. And then Google DeepMind AI piano powers of the next Rambonet. It's again an AI work. It's a 3D painting, an AI generated portrait of Edmund Bellamy, which was sold for this much. And with the recent, creative works which are created by AI, it draws a question on the ownership of such work. If AIs are creative, can they own the IP? This is one of the biggest issues which is surrounding now, which has been thrown open by AI, and that there is an ethical issue in it. So if you're going to give credit to the AI, which is your creation, what will happen to the rights? Who will be claiming those rights? And then can you give a copyright to the intellectual to the artificial intelligence which is, and then if a work is created by AI, whom will the credit go? Who will be the author? Who will be the owner? Whether it's the AI itself or it is the person who has made that program. So this is biggest ethical question. And of course, legal question which is yet to be answered by our present law. And if we see, like, I'll directly take you to the cases, some of the cases. If I'll discuss this Nova Productions, where versus Mazuma Games 2007, where the court in determining if the rudiments of a computer game created the bitmap files, it conferred the authorship to the programmer. Okay, not the person who took screenshots of the game. So in this case, it was said that the person who is making the program will get the ownership right, not the person who is just if we the court held that the programmer indeed had the authorship as he devised the program, and he wrote the program, and he executed the program, so it is he who will be having the ownership rights. Eva Maria Penier versus Standard Vargas GmbH, which is the case of 2012 European Union. The court held an intellectual creation is an author's own if it reflects the author's personality. Again, the decision is Naruto case and the exclusion of non-human authors. This is very important. In this case, the non-human authors, which means that AI, by the US Copyright Office Companion with reference to the works produced by AI without the involvement from a human author is to be interpreted to imply that creative contents of AI does not possess copyright protection under the current legal regime and fall into the public domain. In Beijing, in China, where the Beijing court held in case of Beijing Felon Law Firm versus Baidu, that in interpreting the copyright law of China, held that only works generated by hominids can enjoy copyright protection. Again, very important. But at the same time, the European Parliament has given protection to the robots, advocated to grant legal status to the electronic persons, to autonomous robots for the purpose of protection under copyright. It may also be added that artificial intelligence, virtual artists, and technologies, music composing AIs becomes the first in the world to be officially given the status of composer. So there is a lot of issues which are arising. Even Saudi government has given a citizenship to the robot Sophia. So we have to see in India the debate is still open. Now, if we look to the AI, intersection of AI with patents, this was AI in relation to the copyright, and now AI has also entered into the domain of patents. Under patent law, patent can be granted to inventor. This is the first and the foremost premise. An inventor is defined as an individual or a set of individuals who have invented the subject matter of invention. This eliminates any interference with supports that premise that legislative intention is sought to include inventions, or rather, the possibility of inventions being made by anyone besides humans. That's fine. And legislature never intended, by using the word inventor is defined as an individual or set of individuals, legislature never intended to give right of invention to a person that is not a human. However, with increasing involvement of AI system in invention process, such question demand a legal perusal. Because we have seen now that machines are doing the work of humans. If we see the warfare, there is a global movement in warfare using AI machines and programs. Medicine and pharmaceuticals. When we talk about patents, pharma sector or invention of new medicines of utmost priority. Now, when there is a situation when AI is successfully creating a medicine, and then there will be rise in the issue of patent, of course. There will be an issue who will have the patent. Is it the AI or the person who made the AI? In road safety, we see so many programs have been developed in order to ensure road safety. But then, too, the number of deaths because of road accidents cannot be ignored. It is possible that AI can come out with a solution for the same, wherein we can prevent the loss of human life, like cars without drivers. We see nowadays in America, we are having the cars without drivers, and they are observing the norms of road safety. Now, if that accident is done by that car, who will be responsible? Again, who will have, whether that AI will be responsible or the person. So if you are attributing AI to that, if you are attributing patent to that AI, then that AI should have been responsible. But what about the programmer, the person who made that AI? So he will be exempted at the same time, because if you apply the same principle, that AI can be patented. So there is again a dilemma. There's again a legal issue surrounding these. The new technologies, every day we are coming up with new inventions. Every day we are coming up with many inventions, and the patent law is about all about innovations and inventions. We see technology. There was a. I'm sorry. And then in case of robotics, several AI programs such as AlphaGo, Watson, etc., perform functions such as generating solutions based on massive influx of data. It may be argued that these solutions contribute to the advancement of such science and hence must be granted patent status. So robotics must be granted patent status. Statistics, it has been argued. Now, the situation, according to scholars, is not very straightforward because there are ethical issues involved in it. As the question arises as to who will have the patent right in case of invention by an AI machine or a programmer, whether the patent will be that of a machine or it will go to the programmer. So, the crucial factor for any invention to be granted a patent is whether or not it can pass the patentability criteria. Now, novelty. For indicating novelty, it becomes necessary for invention to be different from whatever exists in the prior art. In AI generated work, will certainly have access to prior art due to its overseeing human scientists feeding in information. So it's truly independent, let alone capable of making a judgment on whether or not its invention can account to something novel. Because ultimately, the AI, which is actually the innovation of somebody, is the person who is innovating this AI must be said to have made a novel invention. So novelty goes to the programmer, not to the AI. And then again, in case of inventive step, as the question of inventive step, if novelty itself is difficult to determine by the AI system, chances of making innovations on existing models or concepts, which is not obvious to a person skilled in the art, is certainly more difficult to achieve. At present, AI usually fed with pre-existing objectives with which they are programmed to achieve. So they cannot go beyond that. So whatever is programmed to the AI, they can do only that type of work. So they lack that inventive step. AI, they lack that novelty. So what I feel is the biggest ethical issues to be answered is that we cannot give patenting to the AI. But of course, it is debatable. It is thrown open for the debate. And then one of again the very important issues, which is again an ethical issue in case of patent, and which raises ethical dilemmas, is the stem cell research. You as the researchers, you as the faculty members might be knowing about all this. Stem cell research has made a groundbreaking contributions to medical science. It offers a potential cure for the disease like Alzheimer's, Parkinson's, and spinal cord injuries. However, the patenting of stem cell related technology brings up an ethical issue that need to be carefully considered. These issues span concerns about human dignity, commodification of life, accessibility, and social justice. We understand that if we are going to patent these stem cells, it will commodify the human life. On the one hand, where there is clear cut, there is a clear cut, restriction on patenting human life because we cannot commodify life. But at the same time, the room has been kept open for biotechnological inventions. But why stem cell research has been hit by ethical issues is, for example, in case of stem cell research, uh, especially human embryo stem cell research. So there is a use of human embryo. And the biggest ethical concern is that embryonic stem cell research involves the destruction of human embryos, which raises the moral questions, particularly those who believe that life begins at conception. The use of embryos for scientific purposes and subsequent patenting of products derived from them is seen as morally problematic for religious and ethical groups who view the destruction of embryos equivalent to taking the human life. And of course, there is a problem about ownership of that genetic material. So you cannot uh, incentivize on life. You cannot have ownership of life. The patenting of stem cells, especially derived from human, raises question about ownership of genetic material. Should an individual or a company have the ownership over the parts of the human genome or the cells they are naturally occurring in the human body? Patenting stem cells can be seen as inappropriate since it involves granting ownership rights over something which is naturally occurring as a part of life, whereby there's a clear cut restriction on Section 3 of the Indian Patent Act that we cannot patent life. Now, if we see the cases whereby Diamond versus Chakraborty, we have understood that has made open the ways for patenting the biotechnological inventions. This landmark judgment opened the door for patenting life forms, but of course, it needs to have certain criteria for that, including potential patents related to stem cell research. But the problem arises in patenting the human embryonic stem cell research. An European office ruled against the patentability of inventions that involve destruction of human embryos, citing ethical concerns. So we have to understand. Of course, this is a very crucial and ethical issue which has been raised by the by whether the stem cell research can be patented, especially in terms of human embryonic stem cells, can be patented or not. So this is the biggest ethical concern which has been in this type of intellectual property. Then one more issue which arises in case of, which is a basic concern again, and which raises some ethical concerns, is pharmaceutical patenting and access to medicine. We see the ethical concerns arising out of pharmaceutical patents. We, on the one hand, see that people should have access to life-saving drugs. People should have access to the medicines which are very important. Which are used for curing the diseases which are life-threatening. So patenting on life-saving drugs can make them probability expensive. They're limiting access in low income countries. This raises an ethical questions about balancing profits with public health. So, at the one hand, you have to patent. If you are giving patenting on life saving drugs, it will definitely amount to incentivizing on those patents, and then abusing the monopoly right in those patents, and also limiting the access to the general public. And this raises a serious ethical question about how will you balance between the profits of one person who is having monopoly in intellectual property, and with the rights of the public, right of the public to have access to public health. So, in one of the important cases, in India, Novartis versus Union of India, the Supreme Court of India rejected Novartis patent application for the cancer drug Glivec, and this is the first case of in itself, emphasizing the need to ensure affordable access to medicines. And then in HIV/AIDS patent battle, if we see, this ongoing global issue involves the clash between pharmaceutical companies holding patents on HIV or AIDS drugs and the need for affordable treatment in developing countries. So we have to maintain a balance between, on the one hand, the rights which are conferred by way of patenting on the persons who are patentees, that is the monopolistic rights, and on the other hand, we have to also have a very important issue, that is access of public to the public health or greater public interest. So these are the issues, and then one more issue which is having its ethical dimension is biopiracy and traditional knowledge. And the patenting biological resources or traditional knowledge without compensating the indigenous community raises an ethical and legal concern. This is seen as an exploitation and appropriation of resources that belong to these communities. First thing is that we cannot generally, as per Section 3, we cannot patent the indigenous work, we cannot patent the indigenous knowledge. But at the same time, if some resources are available and there is a profit sharing bond between the two, We can go for patenting of biological resources or even the traditional knowledge, but there is need of having ethical considerations in that. We need to compensate the communities from which we are taking this. And in neem plant case, we see European Patent Office revoked a patent on the neem tree, recognizing that the knowledge of its pesticidal properties was already known in India. We have seen even in turmeric case. So we are able to get back our patent on turmeric because of the previous knowledge in India, and it has been proved that this turmeric was having the previous healing, used for healing wounds. It was a part of a traditional knowledge. So these ethical considerations need to be balanced. Now, what is the strategy in resolving those ethical dilemmas in relation to the copyright or in relation to the patent? The first and the foremost is that we should have a clear authorship guideline. So, if the project is funded, if the work is funded by an institution, or if a person is working as an employer with some institution, clear rules and guidelines shall be made about the profit sharing. We have to set down the rules for determining the authorship at the very early stage of the project, so that later on these issues, these ethical issues, will not come. And there is a need of having transparent collaboration agreements. So when collaborative agreements need to be very transparent, need to be very clear. So they should define IP rights, and they should already be clear about ownership before starting of the collaborative work. So if a work is started between the two institutions or between the funding agency and the researcher, the terms and conditions shall be clear. That will take care of these ethical dilemmas. And definitely, whenever we are going to do research, we have to adhere to some ethical standards. On the one hand, that is giving an open way to AI for patenting or copyright will definitely hamper the on one hand, it was definitely having effect on the innovations, or it will definitely hamper the innovation. We have to follow the institutional legal guidelines for IP and ethics. So there are ethical guidelines there. We have to follow them. And then, in relation to this AI and patenting, I tell you, it's very important to understand, or AI and stem cell research. Uh, our research, we have seen in America, there are now the babies being developed. So a technology is there. You might have seen, all of you might have seen in your through your internet, that there is a factory for construction of babies. The more money you have, the more intelligent baby you have, the more good looking baby you can have. So but to what extent it is ethical? So we cannot allow these unethical practices to continue, and then give patent to them, and then monopolize these rights. So we have to, at the same time, at the one hand, we have to give respect to the rights of the persons who are innovators or authors, but at the same time, you also have to take care of these ethical principles. So the clear takeaway, concluding what we discussed, is that copyright is very crucial for protecting creators' rights, but presents it also presents ethical and legal challenges such as plagiarism, moral right violations, unlicensed use of software. And ethical and these legal dilemmas are basically inherent in these intellectual property and academic research. But researchers must balance innovation with ethical responsibility and legal compliance. So the call of action is, you have to respect copyright, you have to maintain fair practices, you have to uphold ethical standards to foster a culture of creativity, integrity, accountability, and transparency. Need to have strict adherence to our IP laws and strict adherence to ethics. Thank you so much.
Thank you, ma'am. Thank you so much for this informative lecture. Sir, ma'am, here is a one question
Yes, please.
from one of your viewers. that how
Okay.
should the IP right of students be protected, particularly in cases where their contributions are significant?
Now, the student is having a right to protect his IP right by way of, whenever there is a research, which is a collaborative research between the student and the institution. That is why I told you it's very important to lay down certain guidelines. The university shall have its policy for research, and the person, and at the same time, that policy will govern what will be the contribution of the researcher and what will be the contribution of the university or the funding agency. So it's very important to deal these things at the very initial stage. When I say if you have to do a collaborative research, it is very important and very pertinent that these issues must be at the very earliest stage, so that the students who are doing an innovative work, or the persons or researchers who are doing innovative work, their rights may be also protected, and at the same time the person and the institution which is funding, their rights may also be protected. That's it.
Thank you, ma'am. Thank you, ma'am. One more question is this on your
What
screen, ma'am.
role can
What
academic
role can
researchers Yes, what role can academic researchers play in advocating for their policies that promote global health equity while respecting IPR? When it comes to the role of researchers, uh, promoting global health equity while respecting IPR. Yeah, of course. We need to make a balance between what I said, your right to intellectual property and the access of the people or the public for healthcare. So if at the one end, your research is something which is very innovative, but at the same time, that innovation is very much important for public. So there is one thing which is very very important, that when you which you have to have, that you cannot have abuse of monopoly. You cannot do abuse of. So if you have been given right as a patent, as a patentee on certain patent, there is again a law whereby abuse of that monopoly is restricted. So you need to make a balance. You are having monopolistic rights, but at the same time you cannot abuse those monopolistic rights. So this is how we can make a balance.
Okay, ma'am. Thank you so much, ma'am. Thank you for
Thank you
giving
so
your
much.
precious time.
I
It is
enjoyed
really
my
informative session, ma'am. Thanks a lot.
Thanks a lot. Okay.
Thank you, ma'am.